Think for a moment about how many times a day, you rely on an agreement, big or small. From that coffee you bought this morning to the streaming service you're probably paying for, contracts are these often unseen rules that keep things running. Ever wondered what happens when someone doesn't, well, play by those rules? Maybe it's a nagging thought in the back of your mind about a current situation. Yeah. Well, today we're diving deep into precisely that. What happens when a contract goes wrong? Specifically, what's legally known as a breach of contract.
Exactly. And we've got some really structured, insightful information here that breaks down the core legal principles. It can feel like a dense topic, I know.
Yeah, it definitely sounds a bit heavy.
But our goal is really to extract the crucial understanding, those key takeaways, so you can grasp what's important without, needing a law degree.
Think of this as your shortcut to being in the know. We're going to map out the fundamental meaning of a breach, explore the different ways a contract can be breached, like from delays to shoddy work to someone just flat out saying no deal. And then look at the consequences and, importantly, the ways you can seek a remedy. So let's get started. What's the absolute core of a breach of contract?
Okay, so at its most fundamental level, it really comes down to a core principle in law. Pacta sunt servanda.
Right, the Latin. Agreements must be kept.
Exactly.
Yeah.
Agreements must be kept. So a breach happens when one party does something or fails to do something that prevents the agreed-upon outcome of the contract. Now, of course, there can be legitimate reasons why someone might not be held liable, legal justifications, but without those, it's a breach.
Okay, so someone doesn't live up to their promise. Does that automatically mean the contract is just over, like hitting a reset button?
Not usually, no.
Yeah.
The main ways the law addresses this are either by trying to make the contract happen as intended, it's called a fulfillment, or specific performance,
Okay.
or by allowing the innocent party to cancel the contract, which is known as rescission. But a breach, even a serious one, doesn't automatically dissolve the agreement itself. While, yeah, major breaches can lead to cancellation, figuring out just how serious a breach is, well, that can be more complex than you might think. And interestingly, even if you think the other party's breach has caused you, significant harm, if you don't follow the correct procedures for cancellation, you might actually end up being the one in breach.
Wow, okay. That's a surprising twist.
Yeah.
You mentioned different types of breaches. Our sources highlight 5 main categories. Can you give us a quick overview of these different flavors of contract hiccups?
Sure. We'll be looking at 5 key types.
Yeah.
First, mora debitoris. That's when the person who owes the performance the debtor unreasonably delays.
Got it. Debtor delay.
Second, mora creditoris, which is kind of the flip side. Unreasonable delay by the person who is supposed to receive the performance, the creditor.
Right, the one waiting.
Third, positive malperformance. That's when the actual performance is somehow defective or, just not what was agreed upon.
Bad job, basically.
Yeah. Fourth, repudiation. That's when a party indicates they have no intention of honoring the contract at all.
Just says, nope.
And finally, prevention of performance, where it becomes impossible to fulfill the contract because of someone's fault. It's worth noting, too, that some of these can overlap in real-world situations, while others, like a delay and actually doing a bad job, they can't happen at the same time for the same obligation.
Interesting that they can't all overlap. Makes sense, I suppose. Messing up what you do is different from just taking too long doing it. Let's dig into that first one, then. Mora debitoris. What exactly does that look like in practice?
Okay, mora debitoris, or debtor's delay. It essentially means the debtor has unjustifiably failed to perform their obligation by the agreed-upon time. For it to qualify as mora debitoris, the obligation must be something positive they were supposed to do.
An action.
Right, an action. It must be due, it must be legally enforceable, and critically, it must still be possible to perform, even though it's late. The core of it is either a delay in performing or a complete failure to perform by the deadline.
Okay, so someone is late on delivering something or maybe just doesn't do it at all by the time they were supposed to. What are the specific criteria, the boxes that need to be ticked for it to officially be mora debitoris?
There are 3 main requirements. First, the debt, the obligation, has to be due and legally enforceable. Now, in many contracts, both sides have to do something, right? Reciprocal contracts.
Like buying something. You pay, they deliver.
Exactly. In those kinds of contracts, there's a general understanding that both performances should happen at roughly the same time. So if one party hasn't done their part, they might not be able to complain if the other party also hasn't performed yet. This relates to a legal concept called the exceptio non adimple contractus.
Whoa, okay, another Latin one.
Yeah, basically means I don't have to do my part until you do yours.
Right, like I'll pay you the rest of the money when the entire renovation is finished. Makes perfect sense. Okay, what's the second requirement for mora debitoris?
The second requirement has to do with the timing. Either the contract must have specified a clear deadline for performance,
A fixed date.
a fixed date, or, if no specific time was set, the person who is owed the performance, the creditor, must have made a formal demand to the debtor to perform by a reasonable time, and the debtor must have failed to meet that demanded deadline. This distinction leads to two types of mora ex re and mora ex persona.
Okay.
Mora ex re happens automatically the moment a clear, fixed performance date in the contract passes and the debtor hasn't performed. Think of a delivery date. If the contract says deliver by October 31st, and October 31st comes and goes without delivery, boom, that's mora ex re. No need for a reminder from the creditor.
So a clear deadline in the contract automatically puts them in delay. Simple enough. What about this mora ex persona?
Right, mora ex persona comes into play when the contract doesn't specify a precise time for performance. Maybe it just perform as soon as possible or something vague. In this situation, even if the performance is clearly due and the delay seems unreasonable, the debtor isn't automatically considered to be in breach just because of the delay. The creditor first needs to send a formal demand, like a letter or formal notice. This demand tells the debtor they need to perform by a specific reasonable time, and this demand can be made at any point after the contract has been established. The key here is that the time given in the demand must be reasonable, enough time to actually do the thing.
Reasonable. Depends on the situation, I guess.
Exactly. Depends on the circumstances, what's being asked. Only once that reasonable period passes without the debtor performing does mora ex persona actually arise. And interestingly, if the creditor also sends a notice saying they'll cancel the contract if the demand isn't met, that's called a notice of rescission, the burden actually shifts. The debtor then has to prove the demanded time was unreasonable, which can be pretty tough.
Okay, so either the contract sets a firm date or the creditor has to formally ask for performance by a reasonable date. What's the third and final thing needed for mora debitoris?
The third requirement is that the failure to perform on time must be without any valid legal excuse. Now, this is where it gets a bit nuanced. You might think fault is required, like the debtor had to have messed up somehow.
Yeah, that seems logical.
Well, the legal position, as highlighted in some cases, is that fault isn't actually a strict requirement for mora debitoris itself. You could be in mora just for being late. However, the courts will excuse the debtor if they had a legitimate legal reason for the delay. For example, maybe the creditor themselves caused the delay, or something totally beyond the debtor's control temporarily made performance impossible. The important thing here, though, is that the burden of proving this legal justification, it rests squarely on the debtor.
That's quite interesting. So you can be in legal hot water just for being late, even if maybe it wasn't entirely your fault, unless you can actively prove a good reason. Okay, so what happens if a debtor does fall into mora? What are the consequences?
There are several potential consequences. One kind of unique aspect of mora is something called perpetuatio obligationis.
Okay, more Latin. What's that mean?
It essentially means the obligation continues, it's perpetuated. Normally, if something happens that makes fulfilling the contract impossible, through no fault of either party, like an act of God, the contract might just end. However, if the debtor was already in moras when that impossible event occurred, they remain liable.
Whoa.
Yeah, unless they can prove that the impossibility would have happened anyway, even if they had performed on time and the item was, say, already in the creditor's hands. So the risk often shifts to the delaying party.
Can you give an example?
Sure. Imagine a supplier is late delivering perishable goods. There it's moras. Then a totally unpredictable natural disaster destroys those goods in their warehouse. Because they were already late, they might still be liable for the loss, even though the disaster wasn't their fault. Unless, perhaps, they could show the disaster would have destroyed the goods, even if they delivered on time.
Wow, that sounds like a pretty significant disadvantage just for being late. What other options does the person who was supposed to receive the performance, the creditor, have?
Right. Besides that risk shifting, the creditor can pursue the standard remedies for a breach of contract. They can demand specific performance, basically asking the court to order the debtor to do what they promised.
Force them to do it.
Yes. They can also claim damages to cover any financial losses they've suffered because of the delay. If the debt is a monetary one, this includes mora interest, which is essentially interest charged on the outstanding amount from the date the mora started. The rate is usually set by the Minister of Justice.
Okay, interest makes sense for money debts.
And finally, in certain specific situations, the creditor might have the right to cancel or rescind the contract entirely.
When would cancellation be an option? It sounded like just being in mora isn't enough to automatically cancel.
That's correct. A debtor being in mora doesn't automatically give the creditor the right to cancel. That's a big step. Cancellation is usually only allowed if 1. The contract itself contains a specific cancellation clause that's called a lex commissoria.
A get-out clause.
Sort of, yeah. Or 2, if the timing of the performance was absolutely crucial to the contract. What the law calls time is of the essence. Time can be of the essence if the parties explicitly stated it in the contract.
Like delivery by Christmas is essential.
Exactly. That's an express lex commissoria. Or it could be a clear, unstated understanding based on the nature of the contract that's a tacit lex commissoria, like delivering a wedding cake after the wedding.
Right, obviously too late.
Or, even without such an agreement, the creditor can make time of the essence by sending the debtor a formal notice of rescission. This notice demands performance by a reasonable deadline and clearly states that failure to meet it will result in cancellation. It's important to know, though, that if there's an express cancellation clause, but it doesn't specify a deadline for performance, the creditor usually still needs to first put the debtor in more ex persona, send that demand, before they can actually use the cancellation clause.
So, okay, let's say someone is really dragging their feet on a project, and we don't have a specific cancellation clause in our agreement. I'd need to send them a formal letter saying, basically, you need to do this by this specific date, or I'm canceling the whole thing.
Precisely. That notice of rescission acts as a final opportunity for the breaching party to fix the situation within a reasonable time frame. And the responsibility falls on you, the creditor, to prove you sent the notice properly and that the time you gave was indeed reasonable under the circumstances. There are also, standard components that should ideally be included in both a formal demand for performance and a notice of rescission, clearly identifying the contract, what performance is required, what the breach is, and the consequences of not fixing it.
Okay, that gives us a pretty thorough understanding of what happens when the debtor, the one doing the work or providing the thing, is the one causing the delay. What about when the tables are turned? What is this more creditoris all about?
All right, more creditoris is when the creditor, the person who is supposed to receive the performance, culpably fails to cooperate with the debtor in a timely way. This failure prevents the debtor from being able to actually fulfill their obligations.
So the person waiting is the problem.
Essentially, yes. The key here is an unreasonable delay or lack of cooperation by the creditor that hinders the performance. Think of a situation where you hire a caterer for an event. The caterer shows up on time with all the food ready to go.
Okay.
But you, the host, you aren't there to let them in, or maybe you haven't even told them where the venue is. That could potentially be more creditoris.
Ah, I see. So it's when the person who's waiting to receive the service or goods is actually the one causing the holdup.
Exactly. For more creditoris to occur, a few things need to be in place. First, obviously, the debtor must actually have an obligation to perform. Second, the creditor's cooperation must be necessary for the debtor to perform that obligation effectively. It's important to remember, more creditors can't happen with obligations where someone is required not to do something negative obligations.
Like a non-compete clause.
Right. Or for positive obligations that the debtor can complete entirely on their own without needing any input or action from the creditor. If I owe you money, you don't really need to cooperate much for me to pay you, right?
True. If I'm supposed to paint your house, though, I definitely need you to give me access.
Perfect example. So access to the house is necessary cooperation. If I just owe you money, your cooperation isn't really needed for me to pay you back. What else needs to be in place for more creditoris?
Okay, what else?
The third thing is that the debtor must have attempted to perform properly. We call this tendering performance.
Tried to do their part.
Yes, they have to have been ready, willing, and able to carry out their part of the contract in the way that was agreed upon. So, if a contract specifies a time and place for delivery, the supplier needs to actually show up at that time and place with the goods, ready to hand them over.
Okay.
Fourth, the creditor must then have delayed or refused to accept that properly tendered performance without a valid legal reason. This could be anything from simply not being available to receive the goods, not providing necessary instructions or access, or just outright refusing to accept the performance when offered.
So they just don't show up or say no thanks.
Pretty much. And just like with mora debitors, If the contract set a specific time for the creditor to accept performance and they fail to do so without a good reason, mora creditoris starts automatically mora exorases again. If there's no fixed time, or perhaps if the debtor wants to perform earlier than an agreed date, and they have the right to do that, they generally need to give the creditor reasonable notice of when they intend to perform. This gives the creditor a fair chance to get ready to receive it.
And is fault on the creditor's part a requirement here for more accreditoris?
Yes, that's the fifth crucial element. The creditor's delay or failure to cooperate must be due to their fault. And in this context, fault means things like negligence, a deliberate lack of action, being unreasonable, basically, behavior by the creditor that gets in the way of the contract being completed. It has to be shown that the creditor's actions, or lack thereof, directly caused the non-performance or the delay. If the delay wasn't their fault, maybe something genuinely unavoidable happened on their end, then it wouldn't be considered more creditors.
Okay, so the creditor is being the bottleneck, and it's their fault. What are the consequences for them being in more creditoris?
Well, there are several consequences for the creditor. Just like with mora debitoris, if the creditor's failure to accept performance is fundamental, and if the timing of acceptance was crucial, time is of the essence for their cooperation, then the debtor might have the right to cancel the contract.
The person doing the work can cancel.
Yes. The debtor can also claim damages to compensate for any losses they've incurred as a result of the creditor's delay or lack of cooperation. Maybe they had storage costs for goods the creditor wouldn't accept, or they lost other business opportunities because they were tied up waiting.
That seems fair.
Interestingly, the debtor can even go to court to seek an order for specific performance.
Wait, specific performance against the creditor?
Yes, essentially asking the court to compel the creditor to fulfill their part of the agreement, like cooperating or accepting the delivery of goods.
So the person who is supposed to do the work can actually sue the other person to make them accept it. That's surprising.
It can happen, yes, especially in situations where just getting money damages wouldn't fully make up for the breach for the debtor. Also, if the contract involves both parties performing, the debtor might still be able to claim what the creditor owes them their counterperformance, like payment. Although this amount might be reduced to reflect any savings the debtor made by not having to fully complete their own obligations due to the creditor's delay. Another important consequence relates to what happens to any goods the debtor is holding for the creditor while the creditor is in mora. The debtor's responsibility for taking care of those goods is typically reduced. They're usually only held liable for intentional damage, what the law calls dolus, or gross negligence culpata.
So they don't have to be quite as careful.
Less careful than usual, yes. Ordinary negligence might be excused. And finally, a big one. If it becomes impossible to perform the contract through no fault of the debtor while the creditor is in mora, the debtor might actually be released from their obligation to perform altogether.
Wow.
But the creditor might still be on the hook for their part of the deal, like paying the price, even though they never received the performance.
So even if something beyond the debtor's control makes the actual exchange impossible later on, the delaying creditor could still be liable. That's a really important point to understand. Okay, let's move on to the next type of breach. Positive malperformance. What's the essence of that one?
Positive malperformance is essentially about the quality or the nature of the performance itself. It's substandard or just not what was agreed upon. Our sources highlight two main ways this can happen. The first is when a debtor has an obligation to do something.
An action again.
Right. But they perform it incompletely or with defects. Think of hiring a contractor to build a wall and they only build half of it. Or they build the whole thing, but they use really cheap, flimsy materials that weren't specified. That's positive malperformance.
Okay, incomplete or defective work. What's the second way?
The second form occurs when the debtor has an obligatio non faciendi, a duty not to do something, and they go ahead and do it anyway.
Breaking a promise not to act.
Exactly. For example, if you sell your business and sign a non-compete agreement promising not to open a similar business nearby for, say, 2 years, but then you do open one after 6 months, that would be positive malperformance. Breaching the negative obligation. The key thing here is that it's about the content of what was done or what wasn't done properly rather than the timing.
Got it. So it's not about when the work was done, like with mora, but the quality and nature of the work itself, or doing something you promised not to.
Precisely. The focus is on whether the performance met the required standards or adhered to what was promised. When it comes to how the innocent party can respond, the remedies usually aim at either ending the contract rescission or trying to get the contract performed correctly, fulfillment.
Okay.
And if it's a breach of an obligation not to do something, like that non-compete example, the creditor can also ask the court for an interdict.
An interdict.
Yeah, it's basically a legal order that stops the debtor from continuing the prohibited action. Or sometimes, an order that forces them to undo what they've already done, if possible.
What about canceling the contract because of this positive malperformance? Are the rules for that similar to when someone is just taking too long, like with Mora?
Yes, there are definitely some parallels. If the contract includes a lex concessoria, that cancellation clause we talked about,
Oh.
then the creditor generally has the right to cancel the contract if the performance isn't up to scratch. Usually, though, they first have to give the debtor a reasonable chance to fix the problem, often called a notice to remedy, and the debtor has to fail to do so within that reasonable time.
Give them a chance to fix it first.
Typically, yes, if the clause requires it or if it's implied. However, if there's no specific cancellation clause in the contract, then the creditor can only cancel if the poor performance is really serious. So serious that they can't reasonably be expected to continue with the contract and just be satisfied with getting monetary compensation, damages for the defects.
How serious is serious enough?
Well, that's a judgment call based on the specific facts. A court would weigh the interests of both sides, keeping in mind that canceling a contract is seen as a pretty drastic step, an extraordinary remedy. Also, if the positive malperformance only affects a specific separate part of the contract, maybe the contract is divisible, the cancellation might only apply to that particular faulty part.
So you might cancel part of it, but keep the rest.
Potentially, yes. And in contracts where performance happens in installments, like regular deliveries of goods, if there are repeated defects in the installments, that might eventually give the innocent party the right to cancel the entire remaining agreement.
And if the person who received the bad performance doesn't want to cancel, maybe the poor performance isn't serious enough to warrant cancellation, or they just want the job done right, what can they do then?
Good question. If the creditor decides to keep the contract going, or if cancellation isn't an option, they have a couple of main avenues. One, they can accept the flawed or incomplete performance as a partial fulfillment of the contract, and then they can claim surrogate damages.
Surrogate damages.
Yeah, it's essentially the difference in value between the performance they should have received according to the contract and the defective performance they actually got. Alternatively, they can reject the defective performance outright and then demand that the debtor either perform correctly that specific performance again or pay damages instead of the proper performance if specific performance isn't practical or desired.
Okay, that makes sense. Let's move on to the fourth type of breach, repudiation. This sounds quite dramatic, like someone just throwing their hands up and saying, forget it, I'm not going to do it.
That's actually a perfect way to describe the essence of it. Repudiation happens when one party, through their words or their actions, and crucially, without any legitimate excuse, clearly demonstrates that they don't intend to be bound by the contract anymore, or that they simply won't perform their obligations under it.
So it's an intention not to perform.
Exactly, an unequivocal intention. It's important to understand that simply being late, falling into morte, isn't automatically repudiation. Usually there needs to be some clear indication of an intention not to perform at all, or to perform in a way completely contrary to the agreement. For instance, if a seller says flat out to the buyer, look, I know we signed a contract, but I've decided I'm not going to sell you that car after all, that's a pretty clear repudiation.
Right, it's more than just missing a deadline. It's actively signaling, I'm out, I'm not fulfilling my part of this deal. How do we figure out if someone has actually repudiated? Is it about what they were thinking?
It's actually judged objectively. The key question is, would a reasonable person looking at the parties conduct their words or actions conclude that they don't intend to honor their obligations fully? Interestingly, the person doing the repudiating doesn't necessarily need to have a bad motive or be intentionally trying to breach the contract in a malicious way.
Really?
Yeah. They might even genuinely believe they have a good reason not to perform. Maybe they misunderstand the contract terms. But if their actions objectively and clearly indicate they won't perform as agreed, it can still be considered repudiation from a legal standpoint. Mollifieds or bad faith isn't required.
Okay, so it's about the message their actions send, regardless of their internal belief. And when can repudiation occur? Does it have to be before the performance is actually due?
No, repudiation can happen either before the agreed upon time for performance, we call that anticipatory breach, or it can happen on or after the performance due date. When it happens after the due date, it often just reinforces another type of breach that might have already occurred, like a delay
Yeah.
or a substandard performance, positive malperformance. It adds that element of I'm not going to fix it or I'm not going to perform at all.
Can you give some examples of what might count as repudiation?
Sure. Some common examples include one party improperly trying to cancel the contract when they don't have the right to, or denying that a valid contract even exists in the first place. Also, just refusing to perform their obligations or refusing to accept the other party's performance when it's properly offered, stating clearly that they are unable to perform their side of the agreement, offering a performance that is so significantly different from what was agreed upon that it essentially amounts to non-performance, or maybe giving insufficient notice of termination when the contract requires a specific longer notice period. Even actions like an employer unfairly preventing an employee from doing their job, or a client stopping a contractor from continuing work without a valid reason, could potentially amount to repudiation.
Okay, a wide range of actions, really. So if one party clearly says or does something that shows they're not going to follow through, they repudiate. What choices does the other party, the innocent one, have?
The party who isn't in breach, the innocent party, generally has two main options when faced with repudiation. First, they can accept the repudiation. This effectively brings the contract to an end right there. By accepting, they treat the contract as terminated, and crucially, they are no longer obligated to perform their own part of the agreement either.
They're off the hook too.
Exactly. They can then typically sue for damages resulting from the breach, the loss caused by the contract ending prematurely. The second option is to affirm the contract. This means they reject the repudiation. They essentially say, no, I don't accept your refusal to perform. We have a deal, and I still expect you to perform. They insist that the contract continues.
They hold them to it.
Yes. It's worth noting, however, that there's some ongoing legal debate about the extent to which an innocent party can always insist on performance after a clear repudiation, especially if forcing the breaching party to perform would be highly impractical, wasteful, or perhaps require ongoing hostile cooperation. But generally, affirmation is an option.
Okay, that makes sense. You can either say, fine, it's over, let's calculate the damages. Or you can say, no, we had a deal and I still expect you to hold up your end, possibly with legal backing. Let's get to the final type of breach we're covering today. Prevention of performance. What's the core idea behind this one?
Prevention of performance occurs when it becomes impossible, actually impossible to fulfill the contractual obligations, and this impossibility is due to the fault of either the creditor or the debtor. What's interesting here is that it doesn't necessarily have to be objectively impossible, meaning absolutely no one in the world could perform it. Subjective impossibility.
Meaning just that specific party can't do it.
Right, subjective impossibility where the specific party who is obligated to perform finds they can't do it, even if maybe someone else could, is generally enough to constitute a breach through prevention of performance, as long as it's due to their own fault. For example, if you contract to sell me your unique, one-of-a-kind antique car, and then you intentionally destroy it before the agreed-upon sale date, well, you've prevented the performance through your fault.
Gotcha. So it's about something going wrong that makes it genuinely impossible to complete the agreement, and someone involved is to blame for that impossibility hitting the fan.
Precisely. Fault is the absolute key here. Because if the impossibility arises through no fault of either party, maybe a sudden change in law makes the performance illegal, or, say, a lightning strike destroys the unique subject matter of the contract.
Like the antique car gets hit by lightning.
Exactly. That's usually considered supervening impossibility, not a breach. And it typically leads to the termination of the contract without either party being liable for breach. But for prevention of performance, fault is essential. The legal standard for fault here is generally what a reasonable person in those circumstances would have done or not done to avoid causing the impossibility. And importantly, the burden of proof is usually on the debtor, the one whose performance became impossible to show that their inability to perform wasn't due to their own negligence or intentional act.
So they have to prove it wasn't their fault.
Correct. And one other point, if a debtor is already late in performing, they're in more debitoris, and then they do something or fail to do something that makes the performance completely impossible, it's still considered a breach. But the legal categorization then shifts from just mora to the more serious prevention of performance.
Okay. And what are the legal remedies available when performance is prevented due to someone's fault?
Well, the usual remedies for breach generally apply, but with one very significant exception. You obviously can't ask a court to order specific performance if the performance is now genuinely impossible. The court can't order you to deliver a car that's been destroyed.
Right. Makes sense. So what can the innocent party do?
If the impossibility is total, meaning the entire contractual obligation can no longer be fulfilled at all, the innocent party generally has two main choices. Option one, they can cancel the contract, reclaim any performance they've already given, like a deposit, and claim damages to compensate for their losses. This could include wasted expenses incurred in reliance on the contract or the lost profits they were reasonably expecting to make from the contract being completed.
Cancel and get compensation.
Yes. Option two, in some situations, they might choose to sort of uphold their side of the contract as much as possible. Perhaps they've already done part of their performance and then claim damages from the breaching party to make up for the value of the performance they can no longer receive.
Okay. What if the impossibility is only partial? Like, part of the contract can still be done, but another part can't because of the breach.
Partial impossibility due to fault introduces some complexities. The innocent party's options often depend on how significant that partial impossibility is. The law talks about its materiality.
Materiality, how important it is.
Exactly. If the part of the performance that's become impossible is considered a material or essential part of the overall contract, the innocent party usually has the right to cancel the entire agreement if they wish. However, if the impossibility affects only a relatively minor or immaterial part of the contract might have to continue for the parts that are still possible. In that case, the innocent party's remedy would typically be either a reduction in their own obligation to perform, like a proportional decrease in the price they have to pay, or a claim for damages just to compensate for the missing or impossible part of the other party's performance.
So it depends on how big a deal the impossible part is.
Pretty much. If a very small, insignificant aspect of the performance becomes impossible and the substantial core of the contract can still be fulfilled, that same test of materiality would apply. Is the core bargain still achievable?
What about contracts where the performance is naturally divisible, like, say, delivering a large order of widgets in several separate shipments?
Good question. If a contract is clearly divisible, like those separate shipments, and one specific part of the performance becomes impossible due to fault, maybe one shipment is destroyed, the innocent party can usually cancel only that particular impossible part of the contract. That would then get a corresponding proportional reduction in what they owe in return for that specific part. However, if what they owe in return, like the total payment, isn't easily divisible, they might have the option to either cancel the entire contract or accept the parts that are still possible and claim damages for the part that can't be performed.
And if the performance isn't divisible, it has to be done as a whole or not at all.
Right. If the performance itself is inherently indivisible, then partial impossibility is generally treated much like a case of complete impossibility. The innocent party gets those broader options: rescind the whole thing and claim damages, or perhaps accept whatever partial performance is possible and get a significant reduction in what they owe, or simply claim damages for the value of the missing part.
Okay. And one last wrinkle. What about if the performance only becomes temporarily impossible due to someone's fault? Does that fall under prevention of performance?
Temporary impossibility caused by fault is handled a bit differently. It often links back to mora. In ongoing agreements like service contracts, a temporary inability to perform caused by one party's fault can lead to either mora debitoris, if it's the party who's supposed to perform who caused the delay, or mora creditoris, if it's the party who's supposed to receive performance who caused it, maybe by not being available.
So it's treated as a delay initially.
Often, yes.
Yes.
If a debtor's own actions prevent them from performing on time, they'll likely be in mora when the performance deadline passes, assuming they can still perform later once the temporary issue is resolved. However, if the delay caused by this temporary impossibility makes the eventual performance essentially worthless to the other party.
Like the wedding cake arriving a week late?
Exactly. Then it might well be treated as a permanent prevention of performance, even though the impossibility itself was temporary. And interestingly, if time is of the essence in the contract, the innocent party doesn't necessarily have to wait for a formal mora to arise or for the temporary impossibility to pass. The very act of culpably preventing timely performance when time is crucial can be seen as an anticipatory breach, potentially giving them the right to cancel the contract immediately.
Wow, okay. We've covered a huge amount of ground with these 5 different types of breaches. It's quite a landscape. Earlier, you mentioned that there can be some overlap between them in practice. Can you maybe give us a couple of quick examples of how these different categories might intersect in the real world?
Absolutely, yeah. They definitely can interact. For example, remember the duty not to do something, the obligatio non
Yeah, the
faciente?
non-compete, yeah.
Right. If a debtor breaches that, they go ahead and do the thing they promised not to do, like disclosing confidential information. That's a clear instance of positive malperformance because they performed an act they were contractually obligated to refrain from. Another common scenario is when a debtor's initial delay in performing, being in mora debitoris, eventually leads to a situation where performance becomes completely impossible, maybe due to their ongoing inaction or negligence. Think of letting perishable goods spoil because you delayed delivery for too long.
Ah, so it starts as delay,
Uh,
becomes impossible.
Exactly. In that case, the breach starts as mora debitoris, but then evolves into prevention of performance. The consequences might then shift accordingly. And finally, think about a situation where a debtor is late in performing, so potentially mora debitoris, but they also communicate clearly that they have no intention of ever performing their obligations.
So late and saying, I'm not doing it.
Right. In that situation, the creditor might have the choice. They could treat this primarily as mora debitoris, focusing on the delay and maybe seeking to enforce performance or just claim damages for the delay itself. Or they could choose to treat it as repudiation, focusing on the debtor's stated intention not to be bound, which might give them grounds to cancel the contract immediately and claim potentially broader damages for the loss of the whole contract. Best course of action for the innocent party will really depend on the specific circumstances and what outcome they are ultimately seeking.
It all sounds very interconnected, doesn't it? Even though the legal categories are distinct, how they play out can be complex. And it's helpful that our sources even provided a summary table, kind of laying out the key aspects of each type of breach, who typically commits it, what aspect of the contract it relates to, how it's committed, whether fault is needed if it can happen early. Seeing it all laid out like that definitely helps to solidify the concepts in your mind.
Absolutely. I think having a good grasp of these different forms of breach and, crucially, their potential consequences is truly invaluable for anyone who enters into contracts. And let's face it, that's pretty much everyone, whether it's for personal matters or in a business context. It really empowers you to recognize when things aren't going as agreed and, importantly, to understand what your legal rights and potential remedies might be. And the fact that these concepts can overlap also highlights why it's so important to look at the specific details, the facts of each situation when a potential breach occurs, rather than just trying to slap on a one-size-fits-all label.
So it sounds like whether you're signing a simple service agreement for your phone or navigating a really complex commercial deal, understanding the nuances of these different types of breach delay, bad work, refusal, impossibility can really give you a significant advantage in protecting your interests and dealing with those challenging situations much more effectively when they arise.
Exactly. And, it really makes you think about the bigger picture, too, doesn't it? In our increasingly complex world, with new technologies and innovative ways of collaborating constantly emerging things, smart contracts, AI agreements, whatever comes next. How might these fundamental legal principles surrounding breach of contract adapt and apply in those novel contexts?
That's a fascinating question.
Or maybe thinking more practically, when you consider the various remedies available, from forcing someone to perform to canceling the whole agreement to just getting damages, what do you, the listener, think might be the most effective way to actually address a breach in different kinds of contractual relationships? Is always suing the best answer? Is cancellation always desirable? It's definitely something worth mulling over as you navigate that intricate web of agreements that shapes so much of both your personal and professional